In Fairfax County, Virginia, new allegations in Johnny Depp versus Amber Heard. Amber's attorneys now claiming Juror 15 was never sent a jury notice and should not have been on that jury. Could this overturn the verdict? Plus, new details about who actually paid for Amber's attorneys.
Thank you. So I'll just stop talking.
Thank you. I appreciate it. I want to be respectful of the court's time and the jury's time.
In Akron, Ohio, the phony funeral home trial, day one of the case against Shaunti Hardin, accused of running an unlicensed funeral home and abusing corpses. Tonight, we'll tell you exactly where he was storing the bodies.
There's a wooden box. It's covered by a piece of cardboard. What's inside that box appears to be a body that's covered in plastic.
And on the docket tonight in Broward County, Florida, the Parkland school shooter murdered 17 people and shot 17 others. He's already admitted his guilt. Now, a jury must decide life or death for this killer. We have a preview of next week's case.
I'm really sorry, and I hope you give me a chance to try to help others.
Plus, in New York City, Real Housewives of Salt Lake City cast member Jen Shah proclaimed her innocence on TV to charges of scamming elderly people, but then admitted her guilt in a federal courtroom and now faces up to 14 years in prison. Tonight's 13th juror question: do you think innocent people plead guilty to federal crimes in court? Get ready. This hour of closing arguments starts right now. I'm Vinnie Politan. Great to have you with us tonight. Appreciate it. Let's talk about Johnny Depp versus Amber Heard. You know, this was a civil case, very uncivil in some respects, but a civil case, not a criminal case. When there's a criminal case and there's a verdict, you know, the verdict is the verdict, then maybe there's an appeal, maybe you win. There might be some motions here and there. But when it comes to a civil case, it just seems that civil litigators have a way of just making things more and more litigious, more and more complicated, like the case never ends. When I was practicing law, the thing that I hated about civil cases, hated about civil litigation was these things never end. Like it starts and then it just starts rolling along, 1 year, 2 years later, 3 years later, 4 years later. You have a trial, it's still not over. And that's what's happening with Johnny Depp versus Amber Heard. And you know, everyone's entitled to make the most. Part of the system, part of the process, can be frustrating at times, but it's not over till it's actually over. So, there's a big motion filed by Amber Heard's team to set aside the verdict. Now, this is not an appeal per se. It's an appeal to the trial judge that, hey, listen, you got to set this aside because you messed up during the trial. You either made the wrong decision or didn't realize something was going on. Let's take a look at part of the motion to set aside this verdict. The information, this is, I've never seen this before. The information on the jury panel list appears to be inconsistent with the identity and demographics of one of the jurors. Juror number 15 was apparently born in 1970, not 1945, as reported to and relied upon the parties, including Ms. Heard, in selecting a jury panel. Given the requirements for verification of each juror, it appears the identity of the juror was not verified. It is unclear if juror number 15 was, in fact, ever summoned for jury duty or qualified to serve on the panel. This warrants an investigation by this court to determine if the juror was, in fact, summoned and whether the due process rights of the parties were bypassed. Depending upon the results of this investigation, this may justify setting aside the verdict in its entirety and setting this matter for a new trial. Okay, this is an allegation. Juror number 15 just was not supposed to be on this jury at all. This, like someone showed up at the courthouse. Court TV legal correspondent Chanley Painter has more for us tonight.
Yeah, Vinny, lots of new filings back and forth between Johnny Depp and Amber Heard, all concerning Heard's effort to have that verdict against her thrown out. In her team's recent motion, she raised 7 grounds as to why the judge should set aside the $10.35 million verdict, including seeking a mistrial, alleging juror number 15 was not properly vetted by the court. Now, Heard's latest filing alleges that the jury panel list in the case included a person who would have been 77 years old at the time of the trial, but voter registration information lists 2 individuals with the same last name residing at the same address, ultimately alleging that a son served instead of the father. Well, today, the Depp team fired back at those allegations, writing in part, Ms. Heard's desperate after the fact demand for an investigation of juror 15 based on a purported error in his birth date is misplaced. Ms. Heard waived her right to challenge the accuracy of the information listed in the jury panel by failing to raise this objection contemporaneously, arguing that Heard's team knew or should have known of any discrepancy before trial and did not raise the issue when the juror had been approved by both the court and the parties to sit as a juror. Plus, the Depp team argues she failed to show any unfair prejudice. So, Vinnie, there's also more legal trouble for Amber Heard. She will have to defend against a federal lawsuit brought by an insurance company. The New York Marine and General Insurance Company wants to avoid paying Heard $1 million after her unsuccessful defense in the Depp defamation suit. In its complaint, the insurance company claims it does not have an ongoing obligation to defend Heard because the jury's findings show Heard acted willfully, thus absolving them of liability based on California insurance law, which states an insurer is not liable for a loss caused by a willful act of the insured. I did reach out to Heard's spokesperson and did not receive a reply for comment on that issue this evening. But that's the latest, Vinnie. For now, I'll send it back to you.
All right, thank you, Chanley Painter. Let's bring in our think tank and work through this a little bit tonight. Joining us in Englewood Cliffs, New Jersey, criminal defense attorney, former prosecutor Al Wunsch III, and in Stamford, Connecticut, criminal defense attorney Darnell Crosland. Great to see you both. I want to begin tonight with juror number 15, and let's just presume that what Amber Heard is alleging is true, that a jury summons is sent for dad, but the son is the one who shows up for jury duty. Kind of like pinch hitting for dad, whether it's purposely or unintentionally. Maybe they have the same exact name and you just get a little confused. I don't know. Al, is this a reason to throw out a 2-month-long trial because the son showed up and the summons was actually for dad?
They had to have known before this time that that happened.
You think so?
Because when you sit a jury, you get that information. Part of the voir dire, you get all the individual facts about the people, and you get the different information that comes out with regards to where they live, what their age is, what is, what goes on there. And it's really up to the court to make sure this is the person that actually got summoned, okay? Nobody said a word. Now all of a sudden there's a problem. I don't know how that prejudices Amber in any way. I don't know how that, if the juror was vetted, placed, sat there, listened to the trial, swore that they were going to listen to the facts and go forward with it, what does it matter if it was Albert H. Wunsch III or Albert H. Wunsch IV? It makes no difference.
Darnell, do you agree that if the juror who's actually summoned doesn't show up, it's someone else? In this case, happens to be the son. Perhaps they have the same name. They don't have the same birthday. One's significantly older than the other, obviously. What are your thoughts?
My thoughts are you have to look at what the motion is saying. So, and there's key words in the motion. The motion says whether the individual who showed up was qualified. And the other key words in the motion was may justify a vacating of the verdict. So what they're saying is not too strong. They're saying to this court, let's look to see if this person who showed up was qualified. And if that's what they're saying, then to Al's point, there was a lot of vetting, and what you want to do in voir dire, which is to seek the truth, to see if this person has any prejudice, any bias, any baggage that will cause them not to be able to sit on this panel. That's the qualified that Amber's lawyers put in the motion. And then they go on to say, if so, if the person is not qualified, it may justify a vacating of this verdict. Now, I say this is a great job on their side. I think that what happens here is that they're not asking for a new trial. What they're saying to Johnny Depp's team is, if we win this, let's get back to settling this. And that's what they should have done before this trial in the first place. But what we see in criminal cases as well is if you get a mistrial, that sometimes the prosecutors don't want to try this case all over again. So they end up settling and giving an offer. So I think this was brilliant on the side of Amber's team. And yeah, I support this.
They're looking for leverage to come to some final settlement. Do you see, Al, that ever happening? Like Johnny Depp and Amber Heard agreeing that, okay, maybe you give me a little less money or we do X. I can't see them agreeing on anything.
Well, Johnny Depp did say that he didn't do this for the money. He did this for the principle. Okay, so basically he did make that statement before, so maybe they could work on that. But I mean, they are really grasping at straws that this is going to be the kind of leverage necessary that is going to give them an opportunity to talk down the amount. I don't see it happening.
How about this, though? How about this? How about this? Do either one of you think it's viable that Amber Heard's team says, listen, or Johnny Depp's team demands, you want to settle this, we could settle this, we'll talk about the number, but she has to come out publicly and say, I lied. Right? That's the condition. I lied.
And what do you think the odds are of that happening? There's like absolutely zero. She's not going to get up there and she's not going to contradict what she said, because then she's going to be looking at potential problems down the road on perjury and things along those lines. So she's not going to do that. And I don't necessarily think that Depp would believe that that was humanly possible in the first place. The question is whether or not he really needs the money, wants the money, desires the money. He won in the eyes of the public. He's done what he needed to do. This trial put him back in the limelight. I think he's going to walk away, but that's not going to be the leverage that juror number 15 was too old or too young or not the guy that got the notice. That ain't happening.
I think Al might be missing the point on this. So the idea is not about whether Johnny wants to pay the money or not. The idea is whether, in fact, if a mistrial is granted, he has to do this all over again. And he's already shooting movies and getting back to work. And so that's the point here. In criminal cases, the prosecution often doesn't want to have to do this all over again unless it's some kind of heinous crime. So it's not really about the money. Johnny will come to the table if he doesn't have to do this again, and they can word her apology or lie in a different way. And so if this case is deemed to be a mistrial, then I think that's great leverage.
All right, let's talk. Go ahead, Al.
It would be easier for a camel to go through the eye of a needle than to get a mistrial based on that. It's not happening. This is not a criminal case. It's a civil case, okay? This is not one of Darnell's little 20,050 and scores that he has there, okay?
He's got the streak going, Al. He's got the streak.
He's got the streak, and I'm very impressed with that. I mean, not many people win in the People's Court, and he's won how many times? So we've got a scenario where, like, this is not going to be a new trial. This is going to be, who cares? It'll be appealed, and they're going to say, who really cares?
All right,
and that's it.
Let's talk about Amber Heard and how she paid for these lawyers. Now we've got insurance companies fighting with one another, two different insurance companies. It seems from what's been filed in court that one insurance company was paying to defend Amber Heard and now wants another insurance company to kick in for half of her defense. So I don't think she spent a dime on this. And meanwhile, the insurance companies are saying, we're not going to pay this judgment because what happened here is the jury said this was willful conduct. It's not covered by our insurance policy. Amber Heard, you have to actually pay for this yourself. Even though you didn't have to pay to defend it, you now have to pay the judgment. How significant is this part of the equation now, Darnell, where you've got the insurance companies now saying, okay, enough is enough. We're not paying this judgment, Amber. If you're going to pay, you're going to have to pay. We defended it. You lost.
Well, I think it's very significant because it takes us back to the beginning. When this lawsuit was filed by Johnny Depp, it was about the $50 million. The insurance company either had a cap, they can't pay that, so they decided, well, you better try this case. Now that the case was tried, Johnny Depp wasn't awarded that amount of money, but other things came out, such as the willfulness of Amber's behavior. And insurance companies, as we know, they have actuaries on staff, and their business is to find out how not to pay. That's their business. And they do everything possible, including figuring out what color cars crash more likely. And so here they found her out. And so I think Amber's going to have a real hard time defending against an insurance company who has a team of lawyers when she's already broke in terms of legal fees. And so this is a real blow to her whole morale, to her whole motivation. And so I think it's going to be hard for her moving forward. So even if she gets a mistrial, she has other issues to deal with. So it can't be a good day for her right now.
All right, let's go 0 to 10, guys. 0 to 10, 10 being absolutely it's going to happen, 0, no chance. What are the chances of Amber Heard actually paying the money to Johnny Depp that she owes him via this jury's verdict? Al, 0 to 10.
And I'm going to consult the Magic 8 Ball on this. It says Darnell's wrong and no way. It's a 0.
0, no chance that she pays. Darnell, any chance that she pays Johnny Depp the money that she owes? 0 to 10, what do you think the chances are?
Based on the fact that Elon Musk has walked away from the Twitter deal, I think there's a 10. She'll get the money.
Elon Musk, her ex, he pays everything for her, apparently. We learned that during the trial. All right, Al Wunsch, Darnell Crosland are with us. We'll have our third member of the think tank join us in just a moment. When we come back, the new trial here on Court TV, the phony funeral home trial. What on earth is going on here? Where did this man allegedly keep the bodies? And why? Why would you get into the business and do it the way that he's alleged to have done it? Got much more straight ahead.
What do you want people to know, first of all, about a case like this?
Well, this is a highly unusual situation in the state of Ohio. We pride ourselves, as far as our board is concerned, in following all the laws and regulations in the state of Ohio. I would say Ohio is among the very best states in the nation as far as protecting the consumer. So we want to make sure this is remedied and handled in a very expedient and appropriate way for what has happened.
That was Cheryl Grossman. She is I want to get this right, the executive director for the Ohio Embalmers and Funeral Directors Board. And what she's talking about is the case you're watching on Court TV that started today. Bizarre case, a little different than most cases that we cover here on Court TV, a little bit different. It's involving a man allegedly unlicensed, running a funeral home business and doing some really awful things to folks at a very vulnerable time. You know, you're already breaking down and broken because your loved one has passed away, and then you find out the way your loved one is being treated, and Julie Janae, Court TV legal correspondent, tracking everything that was happening today inside the courtroom. She has more for us tonight. Take a listen.
We're here in the Lucas County, Ohio Court of Common Pleas, where the Attorney General's office is just kicking off against a former pastor. 44 counts they've brought against him for posing as a funeral director. Sean Harden operated many businesses across the state of Ohio. His Facebook page that was shown to the judge as an exhibit, it boasts being certified in funeral services. But prosecutors say he had no license and handled corpses in a way that would outrage society.
At times, this defendant would brazenly represent himself as a funeral director. Flat out, no bones, I'm a funeral director. Other times, he tried to mask what he was doing, and the testimonial described that, well, he didn't use the exact term, but he would describe himself in terms that indicated or implied that he was a funeral director. The defendant had those bodies in the former hair and nail salon. That, Your Honor, is not treating a body with dignity and respect. Ms. Cooper had been around, had passed away over a month before her body was located. In fact, I believe the testimony in this case is going to be that the defendant was misleading the family, telling them that her body had already been cremated. And there she was, lying in a wooden box in the hair and nail salon in Columbus, Ohio. Not dignity and respect.
The state claims Hardin failed to refrigerate bodies and transported them to inappropriate places, highlighting this back room of a church with a bagged body in plain view. And in covering up those problematic practices, prosecutors say he went so far as to intimidate a witness.
After the vehicle dispute, the call goes into the police to come look at that location, and the person gets contacted. The person that had rented that vehicles for the defendant gets contacted. And it says, quite simply, you better watch your back, you snitched. I believe that that person had been the person that called in the complaint to the Columbus Police Department.
Hardin's defense explains an alternative view of a difficult process that most are shielded from.
You don't need a funeral director. You don't need the big homes with all the elegant furniture. We're starting to do it as we used to 200 years ago.
This is a bench trial, so there's no jury. Everything that's coming out in court is in front of the judge. And the state says they actually have a very long list of witnesses that they plan to call over the course of the next 3 weeks. One of the next ones that we expect to hear from is the coroner. Reporting in Lucas County, Ohio, Julia Janae with Court TV.
3 weeks. I mean, there are murder trials here on Court TV that take, like a week. This one's going to take 3 weeks, bench trial, no jury, but really some despicable allegations here. And I think the prosecutor pointed out the right way. Dignity and respect. And that's what's not being done, according to the allegations. Still with us in our think tank, Al Wunsch, Darnell, Crosland, and joining us now, Philadelphia, Pennsylvania, family law attorney Jennifer Brandt. All right, the gang is all here now. Jennifer Brandt, your thoughts about this? This is an unusual case, to say the least. But when you talk about the victims here and the families at that moment where you've lost your loved one, and then you learn that you're just leaving the body out in some hair and nail salon?
It's disgusting, Vinny. It is disturbing and disgusting, to say the least. And I mean, what is his defense? His defense is that we don't need funeral directors, that we're going to go back to the old days and just anybody can bury a body or take care of someone who's deceased. I mean, there's laws licensing funeral directors. He clearly misrepresented himself. He knew he wasn't a funeral director. He knew he wasn't qualified to deal with these bodies. Yet he represents on his Facebook page that he's a certified funeral director. So, I mean, I think they got this guy left to right. I don't really see what defense he has. And 3 weeks, I'm sure we're going to hear from all of the family members and people whose loved ones were treated so poorly due to this man. So, I am surprised it's going to take so long, because I think they could wrap this up rather quickly. But, I'm sure that there are people out there, witnesses, family members, et cetera, who really need to say their piece and tell what happened to their loved ones.
Darnell, if you were called to represent this man, do you think the streak would be broken?
Darnell could do it. Darnell could do it for sure.
Like Jennifer, I'm kind of concerned about their defense. What I have here in my notes is we should do it the old way, the way they did it 200 years ago. No refrigeration, no casket, wrap them in cloths like a mummy. And I'm not sure how that defense is going to work. What I am confused about is more and more of these cases are being tried before a bench. And typically, like I always say, if it's strictly a legal issue, then you go to the bench, because the judge can look at the statute and make a determination. A case like this, if it's strictly a legal issue, then I'm not sure what hope they are going to have before a judge, because if it says you need a license and you don't have one, then guilty. And lastly, he said he's in funeral services business, which means he gives support to other funeral homes. So I think he's trying to, as a defense, say they have the license and they're responsible, and I'm just doing what they told me. So I think as a defense, it looks like he's trying to slide out the back door that way.
Al, you've got a bench trial here. Judges get to hear a lot more than the jurors do. The judges get the whole picture, whether it's evidence that's allowed to be considered or evidence that's not allowed to be considered. So I think he'll have a much clearer picture of who this defendant is. Does that help him or hurt him?
Well, first of all, I want to just say that Darnell puts the word fun in funeral. So just keep that in mind. And this is like every comedian's dream to have this case going forward. I mean, ladies and gentlemen, you know, Your Honor, is it fraud, is it criminal, or just a grave mistake? You know, I mean, these are the kind of things you want to say. You know, it's like his and hers, and things along the line like, we'd like to magically get this thing to go away, abracadabra. You know, I mean, stuff like that. You can have a little more fun with a judge than you can with a jury. And in this case, I think the judge was a good choice. I think a jury would be incensed against this guy for what's been going on. I think it was a very smart move, since it couldn't be worked out, that if you're going to do it, go with a judge who's going to be, I mean, probably upset, but is not going to be as vindictive as I think a jury would be to hear what happened to this, you know, people that were basically delivered to the alumni dinner by this, you know, so-called undertaker.
Let me ask you, Jennifer, because this is a different kind of case than we usually cover here on Court TV. And, you know, let's presume that prosecution wins and he's convicted. Based upon these allegations, what would you see as a reasonable punishment or penalty for what these allegations are?
Well, I mean, definitely jail time for him. I mean, you know, just because the people were deceased and just because, you know, Al is making jokes about it, it is a serious situation. I mean, and, you know, sorry to pick on Al, but, you know, it's a serious situation. And for the people that lost loved ones and you know, had them treated in this manner, I think we have to, you know, show punishment here, because I just don't think it's something that somebody can get away with, you know, and he shouldn't be let off easy. I think as an example for other people who may be thinking about going back to the old ways and, you know, not having licenses to do this, I think maybe it would make some people think twice. So as a deterrent factor, definitely some jail time for him. And plus, I think there's a slew of other things he's accused of. I just think this guy was just, you know, just disregarding the law entirely and really needs to be punished for his crime.
Darnell, you're in the middle of the criminal justice system, defending people and seeing justice the way it's dispensed. What would be reasonable here if he's convicted?
I think, one, the court's going to immediately look at his past. And I'm seeing that he has 37 charges related to the same type of behavior. And I'm not sure how he's still even close to this business after 37 charges. But I think in this particular case, the question always comes, is it one of the worst things you could do is take a life. In this case, lives have already been taken. And the question is, how did he handle those lives? Did he strip these people of their dignity? And that's what we have here. So I would think that this will be a cap argument, not a straight sentence, where the judge is going to have to determine a floor and a ceiling. And they're going to have to get a pre-sentence report done by a probation department and look at all of the backgrounds. And the judge is going to make a determination within a cap. But I would say the cap should be between 5 to 10, based on the fact that these are some serious felonies.
All right. We've got more to get to. When we come back, we're going to take you on the docket. We're getting ready for another case to begin after a long jury selection process. The Parkland school shooter. The jury will have one question and one question only to answer. Life or death for this mass murderer. On the docket tonight, the Parkland school shooter. This case going to trial, set to begin next week. And the jury only has to make one decision, life or death for the Parkland school shooter, because he's already admitted his guilt. And on the day that he admitted his guilt, he made an absolutely bizarre statement inside the courtroom. Let's take a listen.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me. And I love you, and I know you don't believe me, but I have to live with this every day. And it brings me nightmares, and I can't live with myself sometimes, but I try to push through because I know that's what you guys would want me to do. I hate drugs, and I believe this country would do better if everyone would stop smoking marijuana and doing all these drugs and causing racism and violence out in the streets. I'm sorry, and I can't even watch TV anymore. And I'm trying my best to maintain my composure, and I just want you to know I'm really sorry. And I hope you give me a chance to try to help others. If I believe it's your decision to decide where I go and whether I live or die. Not the jury's. I believe it's your decision. I'm sorry.
So this trial will be just the penalty phase. And it's not super uncommon that you have a jury come in and just decide life or death, because we have covered through the years other death penalty cases where maybe the jury in the first time around couldn't come to a unanimous verdict, so they came back and tried the case again with a brand new jury. It happened in the Jodi Arias trial. First jury couldn't come to unanimous, and then they tried the case again in front of a second jury. And that's kind of what's happening here. So prosecutors have to put on the record and in front of this jury what actually happened that day. Not just should he live or should he die, but what did he actually do? So let's bring back in the think tank Al Wunsch, Darnell, Crosland, Jennifer Brandt. Jennifer, I think it's super significant here for this jury, for prosecutors to bring that jury inside the school that day to truly understand what happened. And the only way to do that is to call dozens and dozens of these witnesses and survivors who were there, the 17 who were shot but survived, the other witnesses that were there, for this jury to understand what actually happened inside that school.
Right, Vinnie, I agree with you. I mean, it's most impactful to hear from the actual witnesses and the family members who were affected as a result of his actions. I mean, he admitted his guilt, but I think that the jury really has to get a full understanding of what went down that day. I mean, you hear him now saying that he's so sorry and that he, feels that he can do some good in the world. He doesn't really get into what he's going to do, but nonetheless, I mean, you hear it coming from him. But I think if you hear the other side of the story and what really happened that day and all the people that were impacted as a result of his actions, that's going to weigh heavily on the jury and, help them figure out what to do here. Because otherwise, I think you can't lose sight of it entirely, but I think you need to hear from the people that are there to really understand the trauma that this young man caused.
Yeah, and whether you believe in the death penalty or not, it is the law, okay? Each state decides whether they will have the death penalty. Florida is one of the states that has the death penalty, Al. So from your perspective, what will be the key issues or aspects at this trial that will make the difference for this jury in deciding whether or not it's life or death for the Parkland school shooter?
Vin, when one looks at scripture, and like sometimes you want to do that in these kind of cases to instill that type of seriousness in the jury. You look at the prodigal son. When the prodigal son came home, they killed the fatted calf, okay? And they celebrated that he had realized that he was wrong and he had made amends. And he was allowed to come back into the community. Now, he's not asking to come back to the community. He's coming back to ask to live, to be able to make something of himself, be able to do something with his life after the mistake that he made. I think it's a brilliant move to go in front of the jury. If the trial went on, he would never have testified. They would never have heard from him. They would never have seen him other than a kid with a mask that looked, like a killer. They would have heard these horrible stories without hearing it from him. And he stood up there and he said, I did this. I'm taking responsibility. He gave some convoluted reasons as to why, but he did take full responsibility. He did plead guilty, He's saving the municipality, the state of Florida, millions of dollars in trial time with regards to this without having to go through a full trial. I mean, they're going to do a show because there's victims and they need the victims have the right to be heard. But he has already told this jury, I did it. I'm wrong. I'm sorry. And I think that's a brilliant move.
Darnell, the death penalty is for the worst of the worst. That's who it's reserved for. Does it get worse than this?
I don't think it really gets worse than this. And since we're talking scripture, no sin is greater than any other sin. And that's according to the Bible. But I think what's important here is that the listeners at Court TV understand that certain juries have to be death certified juries. And so every juror that you pick, like the Amber Heard jury couldn't do this. There's a specific process that you go through to make sure you're a death certified jury. And this jury obviously has been impaneled because they have passed that rigorous analysis. And so they have already concluded that this jury can return a verdict of death if necessary. So that's important to understand. In terms of this trial and what this phase is all about, it's a bifurcated phase, guilt or innocence, and then the sentencing. You know, I'm of the mindset that you don't have to use a hammer to kill a nail. We have 17 people that died here. That's enough, really. And if you've been watching this trial, the litigants in this trial, the prosecutor and defense, have been arguing about how much pictures can come in, how much videos can come in, because their argument is that if it's not relevant, it shouldn't come in just to inflame this panel. Because again, you have a hammer, you have an ant. You don't need a hammer to kill an ant. The guy has already admitted that he's killed all these people. And so it's just a matter of fact of, the fact is really just, can this jury return a verdict of death if necessary? And we don't have to go so far to inflame this jury with videos and pictures. We already know this is a bad crime. It's graphic enough. And I think that that's all we really need to be concerned with here.
All right, we shall see. Opening statements, July 18th. July 18th, Parkland school shooter, right here in your front row seat to justice. Now, when we come back, we've got a real housewife in trouble in federal court. There she is. Who is she? Which Real Housewives show is she from? All those answers when we return. There she is, Real Housewife of Salt Lake City, Jen Shah, who has become quite a headline grabber, but not just for being on the show, but for some trouble with the law. And today, that Real Housewives of Salt Lake City star, Jen Shah, pleaded guilty to 1 count of conspiracy to commit wire fraud in connection with a years-long telemarketing scheme. And when asked in court today if she knew what she was doing was wrong and illegal, Shah replied, "Yes, Your Honor." However, she has publicly claimed her innocence numerous times while appearing on Bravo TV's The Real Housewives of Salt Lake City, including during the reunion episode. Take a look.
I'm fighting this. I am innocent.
She's fighting it.
And I will fight for every person out there that can't fight for themselves because they don't have the resources or the means, so they don't fight. I will fight because, number one, I'm innocent, and number two, I'm going to represent every other person out there that can't fight and hasn't been able to.
All right, so we posted a story tonight on social media and asked you, the 13th juror, do innocent people plead guilty to federal crimes in court? Let's bring back in our think tank, Al Wunsch, Darnell, Crosland, Jennifer Brandt, all with us. I want to go straight to our 13th juror, comment of the day on this one. Sue, no, innocent people don't plead guilty in court. If she pled guilty and agreed to pay between $6 and $1 million in restitution, she is guilty. Darnell, do innocent people plead guilty to federal crimes?
Absolutely. If innocent people didn't plead guilty, we wouldn't have any guilty pleas in court at all. And so what people have to understand is that This is the truth. This is the truth. I'm telling you, as an experienced litigator here, this is serious business here. So you get to these particular cases, and she was crying, saying that she's fighting for people who can't fight for themselves. There's a lot of people who go to court who don't have the proper legal representation, don't have the money to pay, and when they look at maybe pleading guilty to an infraction versus taking a chance and having to pay for trial, they take the infraction and they plead guilty to get out of there. So yes, innocent people do plead. Come on.
Darnell, you can't even say that with a straight face. She has the ability to be represented. I mean, come on. She's saying she's standing up for all the people, but we're talking about her.
No. The question was, does innocent people plead guilty in court? And I'm telling you that innocent people do plead guilty in court because that's why they call them plea bargains. Sometimes there's other factors to take into consideration. Now, this woman may be guilty, and that's why she pled guilty, but I was just answering the question directly.
All right, I'll take a look at what Laura had to say. Why would you plead guilty when you're innocent? Speaks volumes. Al, why would someone plead guilty if they were innocent?
Okay, well, and believe it, mark this in your calendars, Darnell is correct that sometimes innocent people plead guilty, okay, because of circumstances beyond their control. Sometimes you have to do something to get something, hence the term plea bargain. And you may not want to do it, but you don't want to take the risk at trial, and depending on what you're looking at. Now, I don't believe that's the situation here. She's certainly not underprivileged. She's certainly not in a position where she could not afford to get the most expensive attorney to defend her on this. She's part of that narcissistic crowd of reality TV so-called stars that just get on there because they want to get on and they want to be famous. Yet they don't realize that their conduct catches up with them. The situation, Teresa Giudice, Kim Richards, the
Giudice.
Giudice. Well,
or Giudice.
Giudice. Okay, whatever. Convicted felons, all of them. But they need their time on the cameras, and they don't care about anything.
Your time on the camera is done for tonight, though, Al.
Al took all my time.
You took Jennifer's time. He does it every week. We gotta start penalizing him. Al Wunsch, Darnell Crosland, Jennifer Brandt, thank you so much. We'll be back with more right after this.